Today, we are diving deep into a true giant of environmental law. This is the landmark Supreme Court of India judgment that basically drew a line in the sand between unchecked industrial growth and preserving a priceless world wonder. This is the story of MC Mehta versus the Union of India, the case that literally rescued the Taj Mahal from the silent, creeping threat of pollution. And for anyone studying environmental law, let me tell you, this isn't just a case, it is absolutely foundational.
All right, so here's our game plan for breaking this all down. We're going to start with the threat to the Taj itself and the citizen-led petition that brought the whole thing to court. Then we'll get into the science the judges relied on, unpack the powerful new legal shield they created, and look at their final, decisive order. And to wrap it all up, we'll explore the incredible, lasting legacy this case left behind.
Okay, first things first. Let's set the scene. We really need to understand not just what the Taj Mahal is, but what it represents, to really get a feel for what was at stake here. The threat wasn't some invading army. It was something way more subtle and, almost invisible.
The Supreme Court's judgment doesn't even start with legal jargon. It starts with poetry. Justice Kuldeep Singh opens by calling the Taj the King Emperor, right away establishing its supreme cultural and aesthetic value. He calls it a fantasy-like grandeur, a monument that impresses the beholder in a manner never to be forgotten. The court makes it crystal clear from the very first sentence. We're not just talking about another building here, this is a piece of the world's soul. But that soul was being tarnished. The petitioner, MC Mehta, brought evidence showing that the famous, gleaming white marble had started to turn yellow and was actually decaying. The judgment quotes the petition word for word, noting that a yellow pallor pervades the entire monument. It even goes on to describe how this yellow was made worse by ugly brown and black spots. The fungal damage was apparently worst in the inner chamber, right on the original graves of Shah Jahan and Mumtaz Mahal. Just think about that. The symbol of eternal love was visibly sick.
So how did this visible decay get turned into a massive legal battle? Well, it wasn't the government that kicked things off. It was a single determined citizen who used a really unique feature of Indian law to make it happen.
And this is the case itself. It was filed by the tireless environmental lawyer MC Mehta. But this wasn't some private lawsuit. He filed it as a writ petition under Article 32 of the Indian Constitution, which framed the whole issue as a matter of public interest and fundamental rights. And that approach, it completely transformed the case from a simple complaint into a constitutional matter of huge national importance.
Now, the key tool here is something called public interest litigation, or PIL. This is just a vital mechanism in the Indian legal system. It relaxes the traditional rule that says only the person directly harmed can go to court. With a PIL, any citizen can approach the court on behalf of a whole group or even for the environment itself when a big public interest is on the line. MC Mehta was basically acting as a voice for the voiceless, for the monument and for the right of every Indian to their cultural heritage.
So who exactly were the accused polluters? Well, the petition pointed the finger at a whole range of industries, all clustered in an area called the Taj Trapezium Zone, or TTZ. This included tons of iron-found trees, chemical plants, and, maybe most famously, the Mathura oil refinery. The main culprit, though, was the industrial use of coke and coal, which were just pumping huge amounts of pollutants into the air all around the monument.
But the court didn't just take the petitioner's word for it. And this is where it gets really interesting. In a move that was absolutely crucial to the final decision, the judges went deep into the science of the decay. They relied on expert committees and technical reports to build an undeniable case against the polluters.
Okay, so this is the chemical reaction at the very heart of the case. The court looked at reports from expert bodies like the National Environmental Engineering Research Institute, or NERI, and these reports explained exactly how sulfur dioxide, which comes from burning coal and coke, was mixing with oxygen and moisture in the air. The result? Sulfuric acid. This acid would then fall as acid rain, which just eats away at the calcium carbonate of the Taj's marble. The NERI report even detailed how this creates a crust on the marble, which then gets washed away by rain, exposing a fresh layer of stone to be attacked all over again. A vicious cycle.
And this science led to a legal masterstroke. Based on all this overwhelming evidence of potential harm, the court did something radical. It completely flipped the burden of proof. See, normally, the person suing has to prove the other guy is causing harm. But here, the Supreme Court said, nope. The onus of proof is now on the industries. They had to prove that their operations were environmentally benign. Basically, they were presumed guilty of polluting until they could prove themselves innocent. This is a huge deal, and it's a direct application of a principle we're about to talk about.
The court's investigation was incredibly methodical.
The Pollution Control Board first identified 510 potentially polluting industries. That's a huge number. But after sending out notices and going through all the replies, the court managed to focus its final orders on this very specific number: 292 industries operating inside the TTZ that were confirmed to be the main polluters using coke or coal.
This case did so much more than just issue orders. It formally brought in and cemented core principles of international environmental law right into the Indian legal system. It created a powerful new shield for environmental protection. So, for all you law students watching, these next slides, they're absolutely critical.
First up, the precautionary principle. The court spelled it out, establishing that the government and the courts have to anticipate and prevent the causes of environmental damage before it happens. And look at this definition carefully. A lack of full scientific certainty cannot be used as an excuse to do nothing. Just the threat of serious damage is enough to act. This is the very principle that justified flipping the burden of proof we just talked about. It's better safe than sorry, but with the full force of law.
The second pillar is the polluter pays principle. And this is pretty much what it sounds like. The court made it crystal clear: polluters are on the hook, not just to compensate any victims, but to pay for the much, much larger cost of actually restoring the environment. The court called it absolute liability, which means the polluter is responsible even if they took reasonable care. It's a really powerful economic reason not to pollute.
Now, what's so crucial here is that the court didn't just pull these principles out of thin air. It grounded them firmly in the Constitution of India. It connected them to Article 21, the fundamental right to life, which has been interpreted to include the right to a clean and healthy environment. It also pointed to Article 48A, which puts a duty on the state to protect the environment, and Article 51AG, which puts a duty on every single citizen to do the same. This constitutional trifecta gives these principles incredible power.
So, armed with the science, the Constitution, and these powerful new legal principles, what did the Supreme Court actually do? Let's break down the final judgment, which gave those 292 industries a stark and, frankly, unavoidable choice. The court's order was beautifully simple and brutally effective. It gave the industries two paths. Path number one, they could switch their fuel source from polluting coke or coal to a cleaner one, mainly natural gas. The Gas Authority of India was actually ordered to help make that happen. If that wasn't possible, well, then they had to take path number two, shut down their use of coal and move their entire operation outside the Taj Trapezium zone. Period. And make no mistake, there was absolutely no wiggle room here. The court said that any industry that couldn't or wouldn't make the switch simply had to stop operating in that area. The preservation of the Taj Mahal was declared non-negotiable. The court was essentially saying that the right to run a polluting business does not and cannot trump the nation's duty to protect its heritage and its citizens' right to a healthy environment.
Okay, so finally, let's zoom out a bit and really think about the impact of this judgment. Why, all these decades later, are we still studying it? Well, because its legacy goes far, far beyond the beautiful white marble walls of the Taj Mahal.
The legacy is just immense. This case formally cemented the precautionary and polluter pays principles as essential features of Indian environmental law. It gave real teeth to the idea that the right to a healthy environment is a core part of the fundamental rights of life under Article 21. It showed the incredible power of judicial activism, with the Supreme Court stepping in where government agencies had failed, and it set a powerful global precedent, showing how a nation's highest court could strike a balance between economic development and cultural preservation. And that really brings us to the final big question this case leaves us with. The conflict between development and the environment, well, it hasn't gone away, has it? The MC Mehta case doesn't give us an easy answer, but it offers a powerful framework. A framework built on science, on constitutional duties, and on the fundamental idea that we have to prevent harm before it's too late, and that those who cause the harm must be the ones to bear the cost. And that is a lesson that is more relevant today than ever before.